Hi, my name is Angel, and welcome to IHR Consulting FAQ. Today I'll talk about termination of contract of service. First question, can a contract of service be terminated by either party? Either party to a contract of service may at any time give to the other notice of his intention to terminate such contract of service. The period of notice required by either party is usually in accordance with the provision in the contract of employment. What are the period of notice of termination for an employer to obey? The period of notice of termination shall be based on the provision of the Employment Act as follows: 1. Less than 2 years at least 4 weeks, 2. 2 years or more at least 6 weeks, 3. 5 years or more at least 8 weeks. How can an employer terminate a contract of service without notice? The answer is, by paying indemnity equal to the amount of wages which should be earned by the employee during the required period of notice. Any willful breach by the other party of a term or condition of the contract of service, in a situation of misconduct, inconsistent with the fulfillment of the expressed or conditions of his service, after due inquiry, can dismiss the employee without notice, and without paying wages in lieu of notice, downgrade the employee, lesser punishment as he deems just and fit, and where a punishment of suspension without wages is conducted, it shall not exceeds 2 weeks. Under what reasons can an employer terminate an employee's services? An employer may terminate an employee's services for any of the following reasons: 1. Retirement, 2. Section 14(1) IRA, misconduct, 3. Willful breach of contract, 4. Retrenchment, 5. Criminal offense, 6. Frustration of contract, 7. Repudiation of contract, 8. Effluxion of time, contract of service for specific period, 9. Termination for poor performance. Next, can an employee be terminated by the employer without a proper cause and excuses? For the employee governed by the IRA 1967, terminated for reasons of redundancy or reorganization or dismiss, an employee needs a proper cause or excuse. However, the industrial court also has the right to interfere into any management prerogatives, and strike down any unfair labor practice or victimization. But the court will not interfere with the bona fide exercise of power, which is given to the management by the common law and by the contract of service, which is inherent in the management. On the other hand, Section 20(1) of the IRA 1967 provides, where a workman who is not a member of a trade union of workmen considers that he has been dismissed, without just cause or excuse by his employer, he may within 60 days of the dismissal make representation in writing to the Director General to be reinstated in his former employment. The representation may be filed at the office of the Director General, nearest to the place of employment from which the workman was dismissed. What happens if the workman is a member or registered under a union? If the workman is a member of a union, his union can file an appeal on his behalf for reinstatement, Section 26 of IRA.